After a short break from the webinar series, Law Gardener is back. A warm happy evening to all the participants who have joined with us for the webinar on anti-defection law. So I hope you have finished your dinner. Everyone who have joined are going to have a dinner, or you can also have dinner and watch this session. It will be both useful and you can also manage time together. And also, as we know that anti-defection law, which was introduced in 1975 to prevent the defection by the members of the political party, as politicians use it to change the parties for any other reason, and they use it to be an earthquake, literally an earthquake kind of situation in the government. And so far the legislation was enacted, and today we are, before starting this session, I would like to thank all the viewers and the subscribers, because we have recently crossed the 1000 subscriber mark, and we seek your same support and for the guidance, and you can suggest us the topics. So before I start, as you know that my name is Nirmal Kumar Jain, and I would like to welcome Advocate Devendra Sharma as our resource person for this session. And I would also like to welcome all the participants, which include law students, lawyers, and common man. So, before starting this session, I would like to give a short introduction of our guest. So, Devendra Sharma sir is a leading legal and business consultant based in Delhi and Jaipur. With his wealth of experience, he has been a very active provider of legal and business advice since 2000. And they are also our guest in our last year. We had a webinar on information technology rules. So they have given us a tremendous knowledge upon that webinar. Also, do check it out. And so their sir's primary areas of expertise include corporate and commercial law, corporate finance transaction, public-private partnership. He has been instrumental in many major transactions, advising strategic buyers, multinational companies, energy and transport ministries, and private investors from number of countries. Sir regularly writes articles for the law journals and speaks on issues relating to the area of expertise. He is a member of CABC Ministry of Culture, member trustee of IGNCA, member of Executive Council of Manipur University of Culture. We welcome you, sir.
Thank you so much, Nirmal, and thank you so much to the organizers, also the law gardeners, and your team.
Thank you.
Few of my friends also, informed me about uh, the way it was the lecture on the IT, the way it was
Yes, sir.
presented and handled. That was quite appreciated by everyone.
Thank you. Thank
And
you, sir.
again, like this issue of defection, the 10th schedule issue, though it is highly in the nature of the, what you can say, the constitutional jurisprudence, though related to politics, so it's quite attractive also. And the way our politician or our politics behave, or rather the more appropriate word is to the politics behave, uh, it's quite remain in the discussion. Unfortunately, because of the technicalities involved in this, people, the common people, or sometimes the professional also, they fail to they understand the nuances related to this. And it is not only in India, at the international, in the other democracies of the world also. We regularly, when we interact, we get such type of feedback that where the majority, most of the countries, democratic countries, they have the parliamentary system, except few countries where the presidential system is there. So in the parliamentary democracies, this is one of the major issue. And in India also, especially in the 60s, when the political hegemony of the Congress started dwindling, and especially in the 66, 67, when the other parties, other than means the Congress parties, they started, gaining influences in the parliament and especially in the state legislatures. And when they try to form the government, right, by the defections and such type of what you can say, the tendencies, the political tendencies increased in the 70s. And we have instances where some of the political leaders, means the legislatures, they change the parties 2 3 times in a day also. So at that time, a phrase "Atma ki awaz," the voice of conscience, it was very very popular to
Yes, sir.
conceal the real, what you can say, the political game plans. So overall, this is basically an issue of, what you can say, the ethics and morality in the public life, and the non-primacy of probity in public life, whereas the politicians or the political parties, they don't follow the normal ethics morality. So whenever there is a question on the ethics and morality, and when they are openly violated or flouted by the users, then it is sort of customary, uh, to enact legislative structure so as to prevent such people who have scant regard for the ethics and morality. In this manner, I want to deal this issue more as a legal issue in comparison to a legal issue. It's more of in legal and ethical manner, where the politicians openly violated the normal ethics and morality. In that situation, which leads to a political uncertainty. So, in order to what you can say, the gaps within the political parties and political systems, though we have Representation of People Act since the early 50s, 1951 or 52, if I can recollect correctly. So they have a very elaborate system of the political parties and the election process. But in spite of all that, there was no check, there was no control over the members of a particular political party as far as the defection is concerned. We know that there are open allurement, and there is a term for horse trading, which is frequently used in reference of honorable member of parliaments and the member of legislatures. So the fundamental issues as far as the reason or the historical perspective, which leads to the enactment of the anti-defection law, and we can understand the importance of anti-defection law, that it is included as a special schedule in the constitution. It is a part of the 10th schedule. When in 1985 the anti-defection law was enacted, it was added in the 10th schedule of our constitution through the, I think, 52nd amendment was there. So the main intent of the legislature, as we just discussed, that was to control the political defections. It means, in simple terms, in layman terms, when a legislature, member of parliament or member of legislative assembly, when they contest the election on a particular party symbol, and after getting after returning as a candidate, winning candidate from that particular constituency, when either on their own volition, right, or due to some other reason that we will deal elaborately in another 10 15 minutes. So that amounts to political defection, that we can say in a general sense. So by understanding this thing, that when the parliament enacted this anti-defection law with the particular intention to control the political defections, so the impact of such legislation raised so many questions as far as the real intent of the democracy, the representative politics, inner party democracy, and most important thing, which At that time, few of the former parliamentarian raised this issue about the anti-defection law. Then in what manner it is giving a brutal power to muzzle the voice of the people's representative, because the voice of the people in democracy, it is possible only when the representative of the people, either in the by the way of member of parliament or by the way of member of legislature, when they speak freely, uh, to express what the desires, what are the requirements of their people whom they are representing in the parliament and the legislative bodies. So that was a big question which was raised, that by such legislation, anti-defection law, the majority or the government or the party in the power, through this act, they the intent was actually to control the voice, to uh, if not killing, controlling the voice of the representatives. So that was there was what we can say, quite a strong dissenting voices at that time also. But the overall environment at that time was in support of this legislation because of the political instability, the way the horse tradings, the political parties indulged to grab the power. So overall, in the 80s, when the Congress party uh, introduced this bill in 1985, Prime Minister Rajiv Gandhi was there at that time, that grew with a very extraordinary majority in the parliament. But the fear of the defection, the political defection, was so strong that even a 400 plus members in the parliament of the Congress was not a comfortable cushion for the Congress party to ensure and to get the feeling, a comfortable feeling that they will continue their term. So that was the basically reason behind that. So as far as the issue of the intra-party debates, free representation, free voices, all these things, that was actually not considered at that time. We know that as far as the overall the right of free speech is concerned, very specifically in our constitution, we have the fundamental rights as far as the free speech is concerned. So the overall framework of the anti-defection law was to control, to regulate the manner, behavior, conduct of the members of the particular party in the parliament, and not only in the floor but outside the parliament also. So that was basically the historical perspective as far as the enactment of the anti-defection law is concerned. Now, what are the important or the critical aspect of this law? If we see, or if we go the plain reading of the statutory provisions of the 10th schedule, they have specifically defined what is house, that includes the parliament and the legislative assembly. I'm just going giving you a brief idea of that, that the house includes the parliament and the legislative body. Legislature party is also defined in there, right, in accordance to the provisions of the representation of people act also. Then the original party and the original political party and the new political party in case of the defection. So there should not be any confusion as far as the which is the original party, means the elected legislature who elected on the particular symbol of a particular party. So these are the certain things which the 10th schedule try to clarify. Now, what will be the implication in case of defection? Because as we have just discussed, that the purpose of the anti-defection law, the intent behind the anti-defection law was to control, to curb. So whether this curve was absolute or there were some exceptions also, because when there was the discussion as far as the anti-defection law concerned, so the what you can say, a small space was also provided for the freedom of conscience of the elected members, that in case uh, if they really want to defect on some serious issues, so their voice should not be absolutely controlled by the party. So there are exceptions to this also. So first, we need to understand what are the grounds of the defections. Now, the first thing, which is specifically described in the Section 2, Subclause 1 of the anti-defection law, that whenever a member of the parliament or the legislative assembly, when they voluntarily given up their membership, right, of such political party, so first thing is that when they voluntarily decides without any force, without any coercion, without any bribery. If we go the understand the theoretical aspect of that, so it should be on their free will. They when they voluntarily decides to give up the membership of that. So that's a first round of defection, or when the provisions for the 10th schedule start working on that person or that member. So first one is the voluntary. Second one is that whenever they abstain from the voting, right, in contradiction to the direction issued by the political party. Right? The political party means he is when as far as his political party is concerned. So and the direction, there is a quite elaborative provisions as far as the direction is concerned. Who can give the direction in what circumstances? There is a method provided within the subclause 2 of the clause 2 of this act. So in that situation, we need to understand that if we generalize it, first, one on his own volition, own voluntary decision to uh, give up the or to drop the membership of the particular party first, and second one is that when they violate to do or not to do certain conduct, certain aspect which is expected from them whenever there is such directions from the authorized person from the party. So these are the things when we can understand that these are the general reason for the defection is concerned. And the third thing is that when expressly in express manner, when a candidate means an independent, when a member of a particular party, when they join the other political party, right, after getting elected on the symbol of some other party. So this is also one of the reason. And another one is when a nominated member joins a political party after the election, right? 6 months after becoming the member of the. So these are the some of the things which are we can say in general that the reason for the disqualification, or which amounts to defection, because first there is need to establish that there is a defection, because defection leads to disqualification, right? Now, the power to disqualify in case of defection, because whether there is defection or not, this is actually the matter of elaborative procedure as the tribunal, the speaker's tribunal, in case of the legislative assembly or in the parliament, the speaker of the house has all the powers to decide about the defection. There is a further debate, and the Dinesh Goswami committee, then thereafter Halim committee, and the law commission also, if I'm rightly recollecting, in 1999 or thereafter, this Constitution Review Committee also suggested some of the changes, because ultimately the speaker, who has the power to disqualify, he is also part and parcel, he or she. I'm using the he and she in common sense, you know. So the speaker of the tribunal, they have the inherent power to decide about that. And but obvious, it's quite natural that the speaker belongs to the majority party. So it is not expected from him to, because it's a quasi judicial position, having the judicial power. But he is in the chair of the speaker, and because he is the speaker, he is the president of the tribunal. So the political affiliation of the uh, person who is having the power to disqualify, it is also a matter of what you can say debate in it. And it's not only a political debate, it's in a pure sense, it's a legal debates having the jurisprudential aspects. So and unfortunately that debate is still not settled. It is almost 35 years, 32 33 years precisely. But this debate is still open, where we see that the speaker's political affiliation uh, pay to fully, respect the intent of this legislation. They fail to honor the intent behind that. So these are the things. Now, as we have just discussed that, because it's overall a democratic process, the election being a people's representative voice and all that. So there are some exception also, as we have just discussed, that at the time of this enactment, few of the senior parliamentarians, they raise objection that the enactment of such law, such legislation, and converting into a law will silence the free voices of the representatives. So, taking care of their objections, the few exceptions, provided in the act itself. Without going into the technicalities, I just in a very brief manner, whenever there is a merger, right? Merger of members of a particular political party, when they merge into or they form a new party or merge. So in that situation, the uh, rule of defection will not be applicable, right? And in that case, a very important, significant, what you can say, ground is there, that in case of any merger on any separate groups, the member should not less be the two-third members of the party, right? So if the number should be minimum two-third, if the number is less than two-third, then they can't enjoy the exception. So the number, but again, when we try to analyze this aspect from the point of view of the practical aspects, then there are big legal debate on this, that what amounts to two-third, it should be at one go, there should be a period or not, what should be. Because normally, if we see the practical politics, which we normally see recently in one of the states where the matter is still under consideration of the Honorable Supreme Court, uh, few people start the few member of the Legislative Assembly started the so-called rebellion, and after that, other rebels slowly and gradually joins them. So, what amounts to, and at what point of time this two-third members need to be considered by the law as the two-third or the requisite numbers, which defies the anti-defection law, the operation of the anti-defection law. So these are the important things which we need to understand as far as the anti-defection law is concerned. So overall, in nutshell, first there was unethical, immoral defection, and unfortunately, it's still not stopped. It is still going on. But the instability which leads to what you can say the political chaos. So, in order to stop all those things, the parliament, after quite what you can say reasonably good discussion and decision, they enacted this law, and they define the grounds or the reasons of the disqualifications of the members in case of political defections, and to respect the democratic norms, they provided exception in case if two-third members of a particular party they decides to merge with other party or to form a separate party. So this is the overall. Now, in case I just want to give for 2 3 minutes to the litigation part of that. Whenever there is a defection takes place, there is need to be a proper complaint before the tribunal, mentioning all the grounds. It's a proper petition in sense what we file in the honorable high courts and the Supreme Court in different types of matter. So, in the Speaker's Tribunal, which is the competent body to decide the disqualification of a particular member, so we file a particular, a very precisely what you can say. Pleadings before the Speaker's Tribunal, mentioning all the criteria in what manner the defection, and we pray uh, for the disqualification of that particular member or the group of members, right? And after the notice, the Speaker's Tribunal invite the proper reply, and on the basis of the reply, complaint and reply, and thereafter evidence, the Speaker's Tribunal pronounce their judgment as far as whether the complaint is or the issues raised in that are tenable, or whether they requires that any action, and if it requires action, then what sort of actions and all that. And it sometimes it leads to disqualification also. Now, there is need to understand one very critical part of that, that specifically at the initial stage, there was no rule of court as far as the defection is concerned at the initial stage. But later on, when there was question as far as the political affiliations of the speakers. So later on, the Supreme Court decides and pronounce certain judgments where they clarify the issue that as far as the disqualification uh, disqualification petition before the Speaker's Tribunal is concerned, they will not intervene in that. But after the pronouncement of the judgment by the Speaker's Tribunal, the court has all the power to go and to scrutinize whether the decision under the anti-defection law is proper or not. So here we need to understand that the court tried to strike a fine balance in between the independent domain of the legislative, because our constitution strongly believes in the separation of the power of the legislature, executive, and the uh, judiciary. So it is really in a nice way. I must appreciate in a manner that the Honorable Supreme Court has addressed this sensitive issue, that um, uh, not to interfere in the Speaker's Tribunal's uh, functioning, working, giving them all the requisite independence, but at the same time taking care of the fact that at the end of the speaker being a part of a particular political setup, uh, if there is some sort of violation by the Speaker's Tribunal, it should be properly, it should be open for a judicial scrutiny. So this is the overall structure of the 10th schedule, the anti-defection law. So I just want to place certain important judgments related to this thing, because in the last 32 years, there are important a judgment by the Honorable Supreme Court, which time to time, in view of the complicated political scenario, Honorable Supreme Court tried to clarify certain issues. For example, in 1993, in one of a very important judgment, which we call it K. Holohan matter, in this, where the constitutionality of this overall piece of legislation challenged, the Honorable Supreme Court given its judgment in favor of this enactment, anti-defection law, and said that it is the enactment of this law or the provision of this law. The purpose is not to subvert the democratic right of the elected members, whether in the parliament or in the legislature, and it's certainly not uh, to uh, control their conscience, right? So they are under a certain obligation when they seek votes from the people from a particular constituency, being a member of a certain political party. So they had certain moral obligations to continue with the political party. So by the Holohan judgment, the Supreme Court uphold the overall constitutionality of this legislature. Now, thereafter, there was a very important judgment by the Supreme Court, that we call it Ravi S. Naik judgment. In this, the Supreme Court tried to explain the meaning of the voluntarily giving up membership. And they said that it's a wider meaning. It's not something which is we need to define in a very restrictive manner. It is a wider meaning. And we need to understand that when a party claim, means in the in the petition, in case of any defection, and when they said that the particular member has voluntarily given up the membership. So in that situation, the Honorable Supreme Court has said that in such scenario, the inference whether they have given up the membership voluntarily, it should be uh, properly, what you can say, drawn from the conduct of the particular member. So whether they have given up the membership or not. So the conduct of the representative of the people in the form of the member or MLA or MP, that is included in this. That was not the part of the original enactment. So the Nayak judgment included this part. Now the third one, which we all know, it was very politically very sound judgment, when in case of the absence of that or the unfulfillment of the two-third criteria, when a member is expelled from the party due to the anti-party activity, for example. So what will be the status of that in case he has not voluntarily given up, he has not joined the party, and there is no application of the two-third part? So in that case, what will be the status of such person? So the court said that in that situation, such member who is expelled from the party may be treated as unattached member in the house, right? So for the purpose of 10th schedule, he remains the member of the party, but because the party has expelled that particular MLA or MP, whatever be the case, in that situation he is considered as an unattached member. So in case after the completion or during that this unattached status, if he joins some other party, in that situation the operation of the 10th schedule start. But in between the joining of the new party and expelling that particular member from the party, he remains an unattached member. So it's a very significant technically, as far as the practical aspect of this is concerned, it's a very, very important contribution uh, to clarify a position which is not defined in the 10th schedule by the way of this G. Vishwanathan versus Speaker of Tamil Nadu Assembly is concerned. Now, again, this another aspect which I want to bring into the notice of all our viewers and listeners, a matter of Goa Assembly. In this matter, where the Speaker of the Legislative Assembly, have the power to review his own decision as far as the disqualification of a particular member is concerned, that was considered by the Honorable Supreme Court. Again, without going into the politics behind that, strictly in the legal terms, confining myself to the legal aspect of that, because there is no power of review of its own judgment provided in the 10th schedule. Therefore, the Speaker cannot create law in its own by reviewing its own judgment. So, the Honorable Supreme Court has said that because there is no such provision in the 10th schedule, therefore, the Speaker has no power to create law at their own. The Speaker's tribunal is seriously inadequate to create the law, which the inherent right uh, uh, possesses. So, Honorable Supreme Court has the inherent right to create the law. So, the Speaker's tribunal has no such right. Now, again, want to bring into the notice of all our listeners. There is another interesting judgment by the Honorable Supreme Court. Uh, in case of the speakers, there is one important, you can also assess that in all the judgment which I have referred, there is a judgment either on the conduct of the member in case of their defection from one party to another, or in case of the expel, where the anti-defection law is silent, or the majority of decisions are on the conduct of the speaker. Right? For example, in another judgment of Rajiv Ranjan Singh, it's of related to Bihar Assembly, when one of the member defied the party whip to vote against the motion of confidence, and his argument was that he was too ill to, to present in the court, to present in the house at the time of voting. So this is again a peculiar situation where the conduct of a particular member was under consideration. So in that case, the order of the speaker was that uh, the abstinence of the particular member uh, and or the what we can say the illness of the member and the illness, the alleged illness which leads to the non-compliance of the whip is not considered uh, as a uh, sufficient ground which excuse that particular member not to present themselves at the time of voting. So that's a very interesting part from the practical politics is concerned. So no one has the right to violate the whip or the directions from the competent authority uh, on the basis of illness or certain things. In another matter, which again related to uh, Bihar Assembly. In this, the speaker, again I am saying the speaker is a competent authority as far as the defection is concerned, as far as the 10th schedule is concerned. So in this, the speaker view was that there are sufficient evidence which shows that the whip issued to a particular member and the delivery in itself substantive in that sense. So there was no question as far as the fact that the whip was properly delivered, and it the argument by the honorable member that it was not delivered to him, that was not acknowledged by the honorable speaker. And in another matter where the speaker in that was a matter related to this Avtar Singh Badana versus Kuldeep Singh. It's a matter of related to the Haryana Assembly. In this, the speaker said that if you elected because of certain policy programs of a particular party, then in case of violation, means in case defection, the moral compulsion and the legal compulsion also. This is again I am saying the speaker's tribunal judgment that such member must go back to the electorate. I personally, appreciate such decisions full of wisdom. It is on the highest, what you can say, the moral and ethical standards which we expect from our lawmakers, like the legislatures and the parliamentarians. Whenever their call of concern say that there is need to change the party or to revolt against the party, then they must go back to their electorate and again seek the confidence of their voters. So this is the overall general framework which I have shared with you. Uh, Besides that, as I said, that it is politically very sensitive matter. Therefore, even after the enactment of the act in 1985, the debate is going on as far as the uh, efficiency of the 10th schedule is concerned, as far as the overall bigger democratic jurisprudential questions are involved in this enactment, as far as the from the point of view of common man is concerned, which who is a silent or rather mute spectator of all the politics, where his role is very limited to casting the vote on a particular day, and before and after that there is no voice of the common man in the existing political existing democracy, though we claim that we are the participatory democracy. But unfortunately, this is not the reality. We all know that. There is no commanding position of the voter. So, from this point of view, the people also hold very strong view about all these things, the political developments. So, taking care of all these things, the Dinesh Goswami committee, which was again appointed by the parliament for the to give advice on the electoral reform, they also suggested that whenever in case of the disqualification of the members, again I am saying that it is a committee report, it is still not part of the uh, uh, 10 schedule. So in the form of there was no, which I will going to tell you all the two, three, four important suggestions. They were considered by the committees, but it's still not the part of the 10 schedule. So what they have suggested that in case where a member voluntarily given up the membership of his political party, or a member abstain from the voting or vote in contradiction to the instruction issued in the form of whip, so disqualification should be limited to only three situations. So in besides that, there should not be any further ground for that. But we know that the situation is not so. As far as the section 2 of the 10th schedule is concerned, there are other reason also there, which are the legal ground for disqualification. Thereafter, there is another Halim committee, uh, which tried to include the uh, Supreme Court judgment, where they define the uh, voluntarily given up the membership of a particular party. So they said that the restriction like joining another party or holding office in the government, all such type of restriction must be imposed on a member who defect from one party to another. It's quite a reasonable suggestion. So whenever because of the some allurement or some benefit which leads to defection, by including such suggestion in the 10th schedule by the way of proper amendment, we can reduce the chances of the political bribery. So whenever there is some sort of allurement or some sort of profits related to defection concern, we can in a manner control such type of things if there is some restriction as far as the giving office of profit or some other benefits to the members who defected from one party to another. And thereafter, the Law Commission also tried to address this issue that, and again, they suggested that the provision as far as the splits and the mergers as a ground for disqualification, it must be deleted from the 10th schedule. And any pre-poll electoral front, uh, they must be treated as a political party under the anti-defection law. And there is need to understand this suggestion in a proper and a comprehensive manner, because whenever a party or a group of coalition, in case NDA for example or UPA, whenever they approach the voters to seek the mandate from them, so and there is any pre-poll alliance, so it must be treated in that manner. So that's quite a very reasonable suggestion from the Law Commission in reference of the 10th schedule. And there is another one that political parties must not loosely use the right to issue whips. WHIP is very important concept. Sorry, I failed to address this thing. That WHIP is it's a sort of legal instruction which is necessary for every member to comply. Whenever this WHIP is issued, every member is bound to comply, because non-compliance of this leads to this defection. That can be construed as a defection. So the Law Commission also suggested, it's a suggestion to the political party, that the whip must be used in a very economic manner. It should not be issued for every issue. So it should not be used. If we try to read in between the lines, the whip should not be used to silence the voice of the member of the legislative assemblies or the parliament. So that's a very significant and suggestions from entirely different dimensions from the Law Commission. Now, the Election Commission also, in some of the discussions, we can say that, because it's a statutory body, so constitutional statutory body. So that they said that Election Commission, that whenever there is a question about decisions under the 10th schedule is concerned, decision under 10th schedule means the decision about the disqualification of particular member or group of member. So it should be with as per the advice of the Election Commission, and it should be binding on the either governor in case of the Legislative Assembly and on the president in case of the Parliament. So this is the Election Commission's suggestion, because Election Commission is the expert body. It is expert body as far as the election is concerned. So the conduct of the elected representatives that that is part of the election commission, or that is a specific domain of the speaker, that's a matter of debate, and the areas are still in the gray category as per my understanding. And though the election commission's suggestion is quite fanciful and prima facie very attractive also, but if we go into the details of this, then there is a conflict as far as the separation of power of the constitutional bodies are concerned. So it requires further dialogue discussion as far as this suggestion is concerned. So how to include the expert opinion of the expert body as far as making decision about the disqualification in case of any defection by a particular member or group of members is concerned. Now, the Constitution Review Commission also 2002, they also said it is basically a reiteration of the earlier suggestion by the Harlem Committee that those who means, defectors, either individually or in a group, they should be barred from holding public office or any remunerative political post for a particular duration. They have not specified any duration, but they said that for a certain duration, they should be legal prohibition. So those who just for the sake of, as we discussed earlier, for some profit uh, or some gains, political gains, those who defects. So such type of tendencies may be controlled. And another suggestion, I'm sorry, there is another suggestion by the this Constitutional Review Committee that those who are the defectors, they should not be allowed to cast the vote as far as the confidence motion, which leads to the change in the government. So these are the few suggestions which we can say that in the last few years of the uh, operation of this law is concerned, by the courts, by the different bodies, and the eminent, what you can say, the seasoned parliamentarians also suggested in last 30 years, 3 decades. And I just I want to conclude this lecture by a very small sort of attention from all of our learned listeners that the overall parliamentary system of governance, the administration where the majoritarian or the majority party in the parliament control the executive, it sounds very ideal and very modern situation if we see on the paper, but actually in reality the situation is not so. In order to control the power, all sort of unethical, immoral practices are part and parcel of this whole situation. And we see that few democracies like the uh, Bangladesh, Kenya, Singapore, South Africa, they have a law, anti-defection law, in their legal constitutional provisions. Whereas certain mature democracies like Australia, Canada, France, Germany, even United Kingdom, from where we have what you can say, we are user of the model created, Westminster model created by our colonial masters. They still don't have the anti-defection law. So it is a continuous debate, and whenever a situation like Maharashtra or Goa or Manipur, uh, because of the political instability emerges, which leads to defection, which leads to formation of the new political coalition post-election. Uh, the conduct of the speaker, it comes under scrutiny, And whenever the issue of the conduct of the speakers comes under the public scrutiny or the legal scrutiny, the efficiency or the efficacy of the 10 schedules, the question about that is also raised in public domain and but obvious in the domain of the courts. So it is still, as I have started, that it is more of a moral ethical question as far as the anti-defection law is concerned. It is still a evolving law because of the dynamic nature of the politics. And in this overall scenario, I think that the overall issue of the reforms in the election process, which is the need of hour, because this anti-defection law is result of, it's a part and parcel of the overall election process. So it is a subset of the election process. So, in the parliamentary democracy, in a representative democracy where the ethics, moralities are, or the political ideologies are not the guiding principle, it is, I, I feel, as far as my experience goes and interaction with the common man, it's a torturous process. People feel cheated that their representatives of the political parties are not doing justice for the sake of power. So by this word, I request to the Honorable Supreme Court that the present scenario, in view of the issue related to the Maharashtra, the recent political upheavals in the Maharashtra, they will seek this opportunity, to provide a broad framework to address all the remaining issues, so that at least those who consider the law as a, as a tissue paper, they will be uh, in a uh, better position to follow it in letter and spirit. So it's a situation where all those people who think about the society, those who are the actively participating in all the discussion, they create a positive environment, and to include all those issues which are still not addressed by the parliament, and where the Honorable Supreme Court regularly intervene because of the such situation, that a proper framework will be available for the people of this nation, which is no doubt the biggest democracy of the world. Thank you so much for giving me this opportunity. It seems to me, Nimal, you are muted. You are muted.
Sorry, sir. Thank you for this wonderful session, sir. You have explained this whole law in very, what we can say, in detail and simpler manner, so everyone can understand. So as we are talking about the Maharashtra crisis also, so we can say that is this. So we have a question from Nikhil RV. So looking at the recent events in Maharashtra, whether judicial intervention would be necessary and how we can manage make the enforcement more stringent. So what's your opinion on this? Enforcement should be stringent or how?
See, whenever there is a political conflict, and we know that the political conflict is for power only, and the case of the Maharashtra Legislative Assembly is also a textbook case where one rebel group, in order to get the, to control the power, uh, by giving reason that the coalition, the new post-election coalition, is not as per their ideological uh, platform. So, and that's quite correct also, that the Shiv Sena and the NCP and the Congress, there is no similarity as far as the ideology is concerned. And that is quite evident that both the fictions are claiming that they are the true follower of Balasaheb Thackeray.
Well,
So Balasaheb Thackeray was never in favor of the Congress and the NCP, though he has very good relationship with Sharad Pawar, but not with NCP. So there is need to understand this thing that the post-election coalition with NCP and the Congress with Shiv Sena, it was not because of the uh, alignment of some ideological goals. Certainly not. So, but at the same time, he was minister, the new CM, and the interesting. That's why I've just said that the this law, anti-defection law, always operate in a very dynamic environment. In this case, the chair of the speaker that was also vacant. So
Yes.
there was another question about the whether the deputy speaker has power or not, right? The role of the whip also, because whip is a very important function. Recently, if I'm rightly unable to follow the news, uh, but they have recently changed their whip in the parliament also, the Shiv Sena. So in all these scenario, there and in absence of a proper authority and the fast-paced manner of the political development by the different stakeholders. So in that situation, I am of this opinion that other than Supreme Court, there is no one who claim the moral and legal authority to settle all these issues. So it's quite obvious that all the parties, in true spirit, they approach the Honorable Supreme Court, and Supreme Court also in it's a demonstration of true wisdom to stop all those horse trading and all that, and continuing with the already existing law, which is laid down in the Bommai judgment, that floor of the house is the what you can say the correct platform to assess the majority. So, maintaining the very sensitive balance in between the constitutionality of all the different independent domains, the Supreme Court intervention uh, created a situation uh, which control the different stakeholders to go berserk. That's what I can say, and
Sir,
it's
as we
necessary. And I'm
know,
sure that by the 11th, the situation will be quite clear before all of us. Yeah, sorry.
yes, sir. So if there is the same crisis goes on and there is a claim of two division that they are the real Shiv Sena, and if there is a case in the Supreme Court who is the real Shiv Sena, according to you, who can win this like title of the Shiv Sena symbol, and will it be Thackeray's or it will be Shinde and their team?
See, the Honorable Supreme Court will not going to decide as far as the symbol is concerned.
Okay.
Right? It is for the Election Commission to decide. Though the Honorable Supreme Court have all the power authority to share their observation as far as the uh, authentic or the majority group of the Shiv Sena. So definitely, as far as my opinion is concerned, the Eknath Shinde group having the majority not only in the assembly but also in the parliamentary board also. And recently, I think out of 67 members, 66 members of the Thane corporation, they also
Yes.
joined the Eknath Shinde group. So considering all these facts, it leads to one conclusion that the elected representatives are with Eknath Shinde faction. And as far as the party is concerned, that is for because as far as the political party is concerned, election commission is the final authority in that. So the present the factual matrix leads to one conclusion that the Eknath Shinde group is definitely uh, have an upper hand as far as the claim of real Shiv Sena and the symbol of Shiv Sena.
So they are like, so we can say that that group can win this race. We can say so.
Yeah. See, ultimately, the political parties, they have to, face the people.
Yes, yes.
So still,
Sir,
I think there are 26, 27 months still. If we assume that formation, this coalition, we complete the remaining term of the assembly, it is for the people of the Maharashtra. So they have,
yes,
as I said earlier, that the voters have very limited, but they have a decisive power in their hands. So ultimately, it is for the people of the Maharashtra to decide who is the real Shiv Sena.
yes, yes, right, sir.
Yeah,
And sir, as we can say, so because of this law, like the members are not able to give proper dissenting opinion or go against the any part of any issue or against the policy of their government. So we can say so like they are ultimately acting like a puppets of the party. They are not able to follow their conscience, sir. If there is any issue regarding any policy.
that's an unfortunate part, Nimble. As we have discussed that during the 60s and 70s, the politics of Ayaram and Vayaram, that's an unfortunate development, and though quite normal also, because uh, at that time it was the overall intent of those who decided for this form of the democracy. I'm not uh, questioning the wisdom of the framers of the constitution, but the experiences of the last 7 decades suggest that uh, this Westminster model of democracy failed because of the corruption and in all the 60s, 70s, 80s, and 90s, the booth capturing, the poll violence. We have recently seen in the West Bengal also the pre-poll or violence, during the poll violence and post-poll violences. It was inhuman. So there is need to think about all these aspects, whether the this form of the uh, democracy is correct for us or not.
Yes,
So
sir.
there are big issues, no doubt, and the efforts to correct the course are less in number, ineffective, and which requires a frequent intervention by the courts, which is in itself evidence that the parliament and all the relevant institutions they fail to fulfill their duties.
Sir, we have a question from like a participant. Why can't Apex Court can initiate its jurisdiction on legislative acts on this law?
Please ask him to just
Same the
explain it
question.
further. Please request to him. This is my request also that please either explain it or reframe it
Shailendra, please
because
reframe the
because because
question.
because the straight reading of this question leads to violation of the law of separation. You know, as the Montesquieu uh, designed, the modern executive and the legislature and the uh, executives, because it is the duty of the legislature and the duty of the court is to interpret that. They have power as far as the constitutionality of that particular. As I said that in 92 or 1993, the constitutionality of this overall anti-defection law was under challenge. So the court has said that it is not contrary to the constitutional norms. Uh, but at the same time, there is need to understand this aspect also that it is inappropriate on part of the court to sit on each and every act, because if the court is supposed to do such things, then what is the use of legislatures? It is better to abolish that.
Yes, sir. Right,
The law-making authority of the legislature, then what's the use of that?
right.
Whether just ask Shailendra whether he reframe his question or
He didn't reframe it, sir. We can go. I have one more question, sir. Sir,
uh-huh.
as you know, Speaker is also a member of a political party. So if we go against his own party, then what will be the scenario, sir?
See, the speaker's chair is a very sacrosanct chair. It is correct that before the election, the speaker, being a member of the that house, maybe a parliament or the legislative assembly, but after the election, he must behave, must conduct himself in an impartial manner. That is expected from him. So this is the first thing. Now, in case of the speaker, his position as a chairman of the tribunal, which is the speaker's tribunal, in such scenario, he is bound, he is under the command and authority of the law. He is not above the law. And recently, in the Manipur's speaker's tribunal's case, Supreme Court has clearly said that as far as the 10th schedule is concerned, the speaker is bound to follow that. Now, what it means? It means that if we jointly read these two situations, that he must behave in a neutral manner, impartial manner, because the speaker's chairs, demand such obligation. This is the first thing. And as a speaker, as a president, as a chairman of the speaker's tribunal, the speaker must behave in true spirit of the. So, but obvious, these two moral, legal conditions disconnect him with his party
Yes, sir.
automatically. But
Go.
unfortunately, what we have seen in the last 25, 30 years, unfortunately, this is not the situation. Speaker normally behave, normally conduct himself in the interest of his party.
It doesn't go against the party generally,
Yeah,
normally. So, Mr. Sailendra has framed the question once again. He's saying that it's ultimately legislature making the laws, but stringent law in force can make this possible. That's it.
very correct. Very correct. I appreciate the way he reframed this, where he pointed out that the laws are not strong enough to stop the defections in the party. So it is, I'm agree with him that law must be, as we have just discussed few minutes back, that the it's a failure. It's a collective failure of the legislature and the speaker's tribunal, where they fail to uphold the sanctity of the 10th schedule as far as the enactment, the bill, the enactment, and thereafter the execution of that law is concerned. It requires much more to be measures. I'm agree with you, Sharadesh.
So we can say that this law is not able to achieve its objective properly for what it was framed.
See, we need to understand that every member of parliament or the legislative assembly, they are politician first.
Yes, true.
So even if we see the original draft and the original enactment, it was basically to control the dissenting voices within the party. It was the allegation at that time that it will be used to, control the or to use the member of party, means the legislative party members, as a puppet by the leaders. So that allegation was not, the experience shows that that allegation was not wrong.
Yes.
So
Right, sir.
it was designed in such a manner to be utilized by those who are in the power. So the
To
real
control.
intent which was presented before the people and the actual intent, there was a there is there was, and that still continues. There is a difference in that. And very important thing which I want to share with you, ultimately, the unethical, immoral politics. It is futile to expect from them that they follow the law. Where the higher moral or ethical law they fail to honor. So it's quite natural.
So I think, sir, we have finished with this question, and so far as the law is concerned, it's doing its part, and it depends upon the moral and morality of the so-called members, how they goes go on with their party. So by this, I think we will be ending our session, sir. Before this, as we have a what we can say culture or something, we just ask one question to every guest, sir. So what is your like advice to the student and the youth to grow in this field, and any other advice you would like to give, sir?
See, in specific reference of the election laws, right? This is the field where we have hardly few lawyers, right? So recently in a Manipur assembly, uh, in election petition, the court has delivered a judgment which leads to a 15 months tenure of a candidate, uh, which was declared elected by the honorable court. So there is need of, you know a more uh, effective and efficient lawyers as far as this. I understand that the litigation is very less. It's comparatively very insignificant if we go by the numbers. But the implication of such litigation is, personally, I feel, a very strong intervention in the overall democratic setup to ensure the probity in the politics and the probity in the public life also. So work hard, work sincerely, and try to understand the philosophic aspect also, because ultimately the uh, what you can say, the superstructure of the philosophy, they guide the ethics and morals.
Yes,
And
sir.
when we try to uh, structure all this ethics and morality in the form of some act, and our institutional system try to implement those acts, so ultimately the value system is very important. So try to understand and treat the law in that sense, the overall value system, which ensure a more civilized society to contribute in the overall development of citizens or human beings in general. Work hard. There is no substitute of hard work.
Yes, right, sir. So work hard and smart work together we have to do to grow. We can say
Hard
so.
work is important.
Yes,
Intelligently
sir.
working is intelligently doing the hard work is more important.
Right, right, sir.
Work smartly is a new phrase. I'm still unable to, understand it.
Go. Yes, sir. So now we would like to conclude this session formally by thanking Advocate Devendra Sharma sir for providing us time, that too in this night time and where people will be busy in their personal life. But you gave us some time and to share their knowledge with us and our participants. And I'd also like to thank you for participating in this session, and be safe and be a law-abiding citizens. Thank you so much, sir. And thank you.
Thank you so much. Thank you so much.